Welcome back, everyone, to Left Undone Incomplete Investigations. I'm Kathy. So, I am going to just do a quick-ish review on what went on today. I just watched the recording, and I wanted to share some spots in it with you all. It's been a while. My life is crazy. As I've told you all before, work is really busy, and my mom is really getting more and more confused. So my life is just a little overwhelming, but I do appreciate those of you that have stuck around with me. It means the world to me, because at some point I'm going to be here full time again, as much as I can. And you know, my channel's 5 years old, and I really appreciate all of you who have been so loyal. Let's go over some of this ridiculousness of Lori Vallow Daybell. I mean, oh my gosh, she sounds to me like a little bratty teenager. So weird. I'm gonna cue up the video and we'll talk about it. All right, I'm gonna start playing it. I'm gonna skip around a little bit because there's just certain parts that I really want to talk about. And you'll see what I mean. But, you know, Lori's Lori. Lori is Lori. Lori thinks she knows everything. She thinks she's the smartest person in the room. And the judge is a freaking saint. So let me start playing this.
Are in the back as spectators might not be able to be in the courtroom tomorrow during the jury selection process. I'm just letting you know. Let's talk about some of these. First of all, for the record, I did get the defendant's notice of objection to the jury questionnaire that was filed on March 20th. The defendant was objecting to, I guess, the phrasing of the allegations that the state has made, and then requested that the fact that she denies the allegation be bolded and underlined it in the questionnaire. I did get your objection. I guess de facto I overruled the objection and the questionnaire went out as proposed.
In the questionnaire to the jury, potential jurors, Lori wanted it to be bolded and underlined that she denies. Let's hear that again. He's like, yeah, no, I denied this from just before you even came in the room. I'm sorry, lady. Crazy.
On March 20th, the defendant was objecting to, I guess, the phrasing of the allegations that the state has made, and then requested that the fact that she denies the allegation be bolded and underlined it in the questionnaire. I did get your...
The fact that she denies the allegations be bolded and underlined in the jury questionnaire. Oh my Lord, this is going to be a show. Gosh, I wish I had enough PTO to take off and go to this trial, but thankfully it is somewhat streaming, so we will get to watch it. Okay. Maybe this video is not going to be as short as I thought. All right, here we go.
Get your objection. I guess de facto I overruled the objection and the questionnaire went out as proposed. Next I have defendant's motion in limine to preclude expert testimony of Daniel Coons dated March 10th. Let me ask the state. That's a Detective Daniel Coons of the Chandler Police Department. Is he going to be testifying as an expert?
Your Honor, we did notice him as an expert in terms of his background and training and testifying as to trajectory. So we did that in abundance of caution, but we did supplement and provide the defense with the background of that. It was provided to the defense more than 30 days before trial. And defense has interviewed him since then.
What was the last part?
The defense has interviewed him since then.
Okay. So, Ms. Daybell, what's the objection?
So for 5 years, of course, he's been on the witness list for to be a regular detective and now he's being put on as an expert, I feel like to give his opinion instead of just stating the facts. So that was my main concern. I don't understand how the trajectory has anything to do with conspiracy. So I object in that way as well.
Okay, she's using some big words that don't even make sense to me. I don't know, maybe they make sense to you guys, but she doesn't want the detective from Chandler PD to be considered an expert in his field because this has been going on for 5 years and he was involved in this investigation.
All right. Has he testified in that regard in the past?
Yes, I believe so, Your Honor. He has been trained in that area and taught in that area. And his relevance, Your Honor, would be because the defense has claimed a self-defense claim as well. It's relevant for that.
Can the state provide me what his opinion is, and does he have a CV?
He does not have a CV. We did actually put the opinion in the supplemental 15.1 that I filed, along with his,
Okay.
I believe, background and training in that as well. So,
I guess let me flesh this out a little bit more. Let me ask the defendant, you've said a couple different things. Are you saying he's not qualified as an expert, or just that the disclosure came in late and you don't think his opinion is relevant?
Well, one, I don't think his opinion is relevant, but also the fact that he's named as a firearms expert. So I don't know if he took a weekend class and that made him a firearms expert. I don't know what his experience was with that. In his CV, it just says firearms expert.
She's such a snot. I don't know if he took a weekend class to become a firearms expert. Like, Lori, how educated is Lori? Lori clearly has not gone past high school education, right? But she is reading books and doing all this stuff. And she says these little narcissistic twists and turns and digs at everybody. This is who the real Lori is. She's not a nice person. She has no respect for other people, for professionals at all. Clearly, she has no respect for her own children or her own husbands. So we'll move on. Let's go on.
So
Did you ask him those questions? Was it you that interviewed him or your investigator?
my investigator interviewed him.
Do you know if he asked questions regarding his
I'm not
background,
sure.
training, or expertise?
Okay, so I haven't listened to that yet, so I'm not quite sure. My concern was that he was a regular detective on the witness list for 5 years, and then 30 days before trial, he's now an expert so that he can give his opinion. And I just thought that was my objection.
Well, if that was your basis of the objection on the timeliness of it, the state did comply with the rules as far as notice prior to trial and giving some sort of summary of what his opinion testimony would be. I'll take a look at it. It doesn't sound like we need any sort of Daubert hearing, but I'll take a look at it. So let's table that for now. Next I have defendant's motion to disclose 404B evidence dated March 14 and the state's response dated March 23. I don't know that the evidence that the state is offering to introduce necessarily 404B bad act per se, but let me hear from the defendant. You got her response?
I did.
All right. So what specific bad acts do you think should be precluded? Or were you just asking for disclosure of what they were actually intending on introducing?
I was asking for a disclosure of 404B that they planned on introducing at trial, and what I got was another theory of the case. So I didn't think that any of it was 404B relevant.
Well, I think I agree with you in so much as what was listed in their response, I wouldn't necessarily characterize as 404B evidence. But you have received that, and now you're aware of what they plan on introducing.
Somewhat
Okay.
correct.
I don't think I need to make a ruling on that. If there's evidentiary objections, hearsay, foundation, those types of things will be taken up when the state elicits or attempts to elicit that information. I have next defendant's motion to exclude state witnesses dated March 14 of 2025, and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why
So she doesn't want Kay. She doesn't want to come face to face with Kay. You know she doesn't want to cross-examine her. And Christina Atwood and those other friends of hers, she don't want them coming near her because Lori doesn't know what she's doing. And this is going to be a shit show. Anyway, I think it's kind of funny that she's already put these motions in that she doesn't want this witness or this witness or this witness. So, you know, she's having her little tizzy fit. I will continue.
the state's going to offer some sort of testimony from these three witnesses that are going to talk about, it'd go toward the element of premeditation and or motive. So what is your objection specifically?
Yes, Lori, you did premeditate. Well, you know, we're not on the jury, so we can just say what we know. You did premeditate Charles's murder. And people know this. And there's been evidence. And Kay was told, and that's why he was changing the insurance, you know, life insurance policy. And Christina was in your little circle of hocus pocus people. All right, here we go.
Mine, Your Honor?
Yes.
Oh, my objection was that after their interviews, after their defense interviews, that it came to light that their information came, well, one specifically came from Dateline, and then they called each other and their information came from each other. So
How would she even know this? The information, Dateline was just on, if that's the Dateline she's talking about. I mean, I don't know. And they all called each other. Kay and Christina Atwood, they all called each other. And so she got this from her investigator interviewing them? Come on. All right. Okay. She makes this thing more confusing than it needs to be.
I guess I'm working a little bit in the dark. What information is that?
whatever they're, I don't know, planning on testifying about, none of them have personal knowledge of any kind of crime, so.
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information?
Yes, Lori, they don't have evidence of a crime, but they know what your blah, blah, blah mouth said to them and to other people prior to Charles being murdered. And when you sat there on the curb with Tylee that day saying, sorry, neighbors, you were not a remorseful looking or a sad or a person that actually whose husband just got shot by their brother. You were ready to have a party. Your whole attitude was ready to have a party, Lori. Okay, let's continue. Oh, this is unbelievable that she's literally, I'm still blown away that she's literally going to represent herself. She's representing herself. Here we go. Judge.
Information is that, let me ask the state. Or what's your offer of proof on why they're relevant?
Did you hear her sigh? I'd be sighing. Oh, the poor judge. Oh my God. Okay, hold on. And the poor prosecutors. Oh my God. Poor everybody that has to be involved in this. Poor jurors. Oh, those poor jurors don't know what they're in for. Whew.
Relevant.
With regards to Christina Atwood, she is a person who was present when the defendant was speaking about the victim being possessed, which goes to, again, the motive of this as well as the premeditation, and that those statements were made months in advance of the actual murder. With regards to Nancy.
So that's going to be offered as some form of admission from the defendant.
So that would be admission by party opponent, and that's personal knowledge.
Did you say that was Nancy Jo Hancock?
So that was Christina Atwood.
Christina Atwood.
Yes, Lori, you opened your big mouth and you told everybody that Ned, Iplos, the H is silent, all this was this possessed person and Charles isn't there anymore. You told them this. This is people that were going to be able to say, yes, she directly told me that he had to be destroyed.
Nancy Jo Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and.
Now, if I have it right, Nancy Jo that they're talking about was the woman that went on a date with Charles the night before.
Expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay. And then
Haywood.
So Nancy told Charles, you probably should tell her that you changed it, because if you're not worth the $1 million, she may not kill you, right? But she still thinks that he's worth the $1 million to her.
Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive. And she also has information relating to the victim himself. There are allegations, again, of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
all right. Do you want to have further argument?
There's that sigh again. How disrespectful is she? Like, she's like, all of a sudden she's a actual lawyer and she's a snob and she's better than everyone in the classroom, in the courtroom. She's the smartest person in the room. Ooh, this woman makes me crazy. Oh my God. Oh my God. I'm going to have to comment on this whole entire trial. You guys are going to probably get sick of me posting.
Just the fact that this information that is supposed to be coming forward is not. All these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand. And then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this. And I would like them all precluded.
Okay.
I don't like them. I don't want them to talking to each other about me, and they're full of baloney because I didn't do anything wrong. You know. Oh my God, Lori. Okay. Yeah. So they're all talking to each other. What is she? She's so paranoid about that. Like, I'm pretty sure Nancy Joe, Christina Atwood, and Kay Woodcock are not buddy buddy. They're just not even from the same cloth of anything. Kay's in Louisiana. Nancy Joe dated the guy a little tiny bit. And Christine Atwood's one of Lori's old friends that got mixed up in this mess and probably is very grateful she got kicked out of the group for texting Chad too much or whatever she did.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that based on the states of Vallow that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to if they're testifying to hearsay or something like that.
Okay, Lori, let's explain this. Okay, Lori, let's explain this. When they're on the stand, you can object and say this is hearsay. We're not going to tell the whole story to the judge before the jury gets in. That's just not how it works, lawyer, attorney at law, Lori.
Next I have, is there a Mr. Eaton here appearing?
Oh, here we go. Here comes the Ned Eaton part. Lori's just getting shut down left, right, and center, and I love it. I love it.
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion over the weekend. Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was.
Did I say Ned Eaton? Oh my goodness, I'm thinking Ned. Oh my God. Nate, sorry.
Listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho and based on the filings believes he doesn't have any relevant information and shouldn't be.
He doesn't have any relevant information. He never heard of Lori when Charles. Does Lori understand that this is a trial regarding what she did that led up to Charles being shot and how she was involved in the conspiracy? Somebody needs to sit her down and explain this. This isn't about Ned chasing you down in Idaho, in Kauai after the fact. This isn't about Ned following the case and being in all the courtrooms. This isn't about, why do I keep saying Ned? What is wrong with me? Nate being in the courtroom. This isn't about Nate. This isn't about what Nate knew afterwards. Like, I mean, that'd be like, I'm not a reporter, but that'd be like Lori summoning me or saying that she wants me to be on the. I never heard of Lori. I didn't know anything about Charles until the kids were missing, right? Same with Nate. That's how she tries to act like she's so smart, but she's not making any normal sense. Like none of her logic is making any sense to me.
Be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off the record conversation with the prosecutor. And he's kind of made himself a witness. He's kind of made her a witness.
How so?
in the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he
Okay.
a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So
Let me explain this to you, and he's doing a very good job, but Lori isn't listening. Lori doesn't listen. How is Nate Eaton relevant to the fact that you are being charged and on trial for conspiracy to kill Charles? Nate never met Charles or you, Lori. This judge is going to lose his mind by the end of this. He's very calm, but oh my goodness, that guy's going to need a drink after work every night.
how does he have relevant information for what this case is about?
Okay, so initially, when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
Okay, so she wants Nate to be there to say, oh, what they're saying on the stand isn't what they told me when I interviewed them. So she wants Nate on her side. Sorry, I've already watched this. I've already watched this twice. And anyway, yeah. So that's what she wants Nate to be her buddy, to go, oh no, they didn't say that to me in the interview. I'll just play the interviews then.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory, she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law And we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do.
Exactly. Exactly. Just play the interview, Lori. If you know that this is going to be something contradicting itself from on the stand versus the interview, submit the interview as evidence. Done.
To do the impeachment, because you could impeach them with the interview by playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but
I'm trying not to give you legal advice because you should have went to law school and passed the bar by now. You want to do this, you are held to the same standard as people that have passed the bar and went to school for a long, long time.
if the witness admits that's them on the interview and that's their statement, that is foundation. So
He's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
well, when I say witness, I mean generally any witness, regardless of their occupation. So
See what I mean? She doesn't even understand that a police officer can actually be a witness. I'm not talking about any witness. I'm talking about law enforcement. She's in way overhead, people. Tell me what you think in the comments, please.
I don't foresee, I see it in only the narrowest of situations where he could even be called to as a extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay?
We could just call him up from the back?
Well, we'll address it when and if it comes, yeah.
And Your Honor, I would ask,
We can just call him up from the back. Come on down. You are the next contestant in the Lori Vallow trial. Like The Price is Right or something. Oh my God. Okay. Sorry, I'm sighing like Lori now.
would ask that if that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Thank you, Your Honor.
All right, thank you.
So that last motion right there, I'm just fast forwarding through it because it was from the prosecutors just not wanting any email addresses or phone numbers of the witness that will be up on the screen to be sent out to the world to get this. So like, we can't call them, or news reporters are going to be like, oh, there's the phone number, let me call them. So nothing exciting. Lori agreed. So moving on.
As of now, is not a witness. Next, we have I don't know how to pronounce her name. Is it Viasia?
Vicia,
Vicia?
Ita Iha.
Is this one of the ones the state was able to get a?
That's Tylee's friend, Vicia, right? The one that has been interviewed and stuff.
No, Your Honor, we did call the numbers and left voicemail. I've not had any response, and it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right. What about Gabriel Bonilla?
Your Honor, I had an update on that one in the sense that on Saturday, so when the state interviewed
Gabriel Bonilla, isn't that the bishop? Charles's bishop? That was there. That got called the night that Lori was in the being interviewed in the police department about being psychotic when he wanted to get her locked up. And he was with Charles when he was trying to get into his own house that night.
Again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints. He advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that person's been served or if they have relevant information.
According to the attorney, Matthew Ballard, he has not been served.
All right. What about, well, let's.
I actually think Bonilla would probably be a witness that should be there because he was there when in January when Charles was trying to get Lori committed or evaluated, 5150'd. And then all the police were like, she's so pretty. Isn't she pretty? There's nothing wrong. Don't answer the door when they come to take you. It's okay. You don't have to. You're so pretty.
Why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12 on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think that there is potentially minimal relevance from Summer Shiflett.
Shizlet?
I think that's a misspelling
Oh.
of her sister's name.
Okay.
I think there's potentially minimal relevance for Janice Cox, her mother.
Okay.
So Summer, Lori's sister, and Janice are on the witness list to be called, but I don't know how much they're going to have to offer on this, right? That's what they're saying.
Adam Cox is actually on the state's witness list, so we don't object to him. I did speak with Zachary Cox.
Can you imagine? Lori's going to cross-examine her brother up there, maybe her mother and her sister, which they said that's minimal that they will be called. So Summer's probably not going to be called. Janice probably isn't going to be called, but Adam will be because Adam was texting Charles. He was supposed to meet him that morning.
I'm not aware of any relevance as to this case from him.
Zach was with his dad, so there is some relevance because Zach was probably a good somebody that would have some information possibly about that day, because him and his dad couldn't get a hold of Charles, so they just took off and went to Tucson. That was always weird to me. Still weird to me.
But I did speak with him.
I see in your pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
All right.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these?
Oh, here we go. Here we go. Lori's on a rant. This is what we're here for, people. Wow, we're here for in all. I mean, please don't take it the wrong way when I say that, because we are here for justice for Charles. But she's putting on her shit show, and we got a popcorn going, because how much worse can it get at this point? She wants us to be entertained by this nonsense. Here we go.
These witnesses before in the last 5 years since this case started. They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right.
That was a little temper tantrum-ish, huh? Oh, Lori.
Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case.
But she wanted a speedy trial. Lori wants her cake and eat it too. And that cannot happen. And he's very clear about that to her. I know she doesn't like the answer, because Lori doesn't like any answers that aren't in her favor.
So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side, with the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dorkin late in the game that they did. I've done everything in my power as a defendant to prepare the state, and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say...
And I shouldn't be able to represent myself because of that fact? That negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks.
Yeah, word salad, blah, blah, blah. She is so unspecific about what she's talking about. She rambles and she goes in these weird tangents and doesn't make any sense. It's all vague. And this judge doesn't know this case like we do. And she acts like everybody on the planet knows who Lori Vallow is and everything about her, because she thinks she's famous now. Not as many people know about her as she thinks, just because she was on Dateline and she looked like a fool there.
That makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said.
Tell him how it's relevant, not just blobbity blah, blah, blah. It's relevant. I'm relevant. It's relevant. She doesn't give any specifics.
About your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview.
I just had a thought. She wants Summer. She wants her mom up there. She wants them to look her in the eye. And she knows how hard this is for them. And she wants them to slip up and say something that's going to protect her. That's what I think she wants. And you know what? To be completely honest, I can see that could happen. Mostly with Janice. I can see she's the mother. She's elderly. I can see Lori manipulating her into saying something that protects Lori. So, I don't know. This is just my thoughts. I got all kinds of thoughts.
Interview. They have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this other than maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is obviously I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them as well as the defense investigator that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point, then the state can try to at that point preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them.
Where'd everybody go? Are they on an island somewhere in the Caribbean in a tent hiding out? They don't want to be called to this trial, Lori. I mean, would you? Like, enough is enough. Bring the people in that have the evidence. Get this dang thing over with. Lori's turning it into a drama, a soap opera.
I think that at this point, precluding them is proper.
Well, would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony's relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're going to have to take up maybe on a piecemeal basis, but I don't want it. It's not going to be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably.
If I could call them myself, they would answer the phone. Really? Maybe.
And I could have this discussion with them, but I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So
again, Miss, I'm working overtime. You didn't have to have a speedy trial. You could have taken more time, acting like she feels all so sorry for her investigator and people that are working and helping her. Wah, wah, wah. But at the same time, you know, here's this whole cake and eat it too thing again.
we are doing the best that we can.
Okay. All right. We next have defendant's motion to dismiss for violation of confidential communication and the Sixth Amendment dated March 18 of 2025 and the state's response.
Motion to dismiss. Here we go.
Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line.
Does anyone think that her appeal would actually be granted? I don't. We saw that trial. They didn't even put on a defense, but that is one of the reasons why I guess she could legitimately appeal, because she had a shitty defense, but that was all her. I still don't think that her appeal would ever be granted, but we shall see.
And really, that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential, and you're told it's not confidential.
Okay, so there are confidential things that are in our communications, because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review. If she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney, I have no other way to communicate with him when I'm in this incarcerated situation, because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with.
Which is a federal offense. She's reaching. Okay, I'll keep going. I'm kind of getting over her now because this is temper tantrum day, right? But we must continue.
What has happened here?
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client-attorney
Well,
privilege.
not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number, or I call that phone number.
Correct.
So
If you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
But I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client-attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
All right, let me hear from the state.
Your Honor, I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrect?
Oh my goodness, Lori. If your attorney isn't using the phone number that he set up as the confidential line, the system isn't that sophisticated. We'll be like, oh, we have facial recognition. Oh, we have voice recognition. Oh, we can't listen to this. Like he's calling through some other IP address. Why doesn't Lori get this? I get this. I don't think it's that complicated to understand. This is between you and your attorney, Lori. Your attorney isn't following what he actually set up. So how is this our problem here in this court today?
Correctly.
I just told you. He's not messaging through the phone number. He's using different IP
How
addresses.
can you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages.
I'm just.
Lori does not understand what an IP address is. Let's look this up for a second. An IP address, Internet Protocol address, is a unique numerical label assigned to each device connected to a network, acting as a digital address that allows devices to communicate across networks, including the internet. An IP address is a string of numbers, such as 192.168, blah, 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 or whatever, that identify a device on a network. Without IP address, devices couldn't find each other to send and receive data. When you access a website, your device sends a request to the server hosting the website using the server's IP address to find its location. Type of IP address is public IP, private IP, dynamic IP, static IP, blah, blah, blah. So whatever his IP address is that he's making a phone call through the internet versus through his phone or something like that, yeah, it's not going to know who the heck it is. So yeah, this is a Lori and her attorney problem. All right, back to the court. I was going to say show.
Just saying, where are they obtaining those from?
From your attorney's messages to you?
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses.
Okay.
Lori, lawyer. If you're smart enough to be a lawyer, you're smart enough to understand that he's not calling you directly through the phone. That was set up to be confidential so that the system recognizes that. She doesn't get it, you guys. She does not belong here as a representing herself. She doesn't get it. Ugh. But again, she still thinks she's the smartest person in the room.
Can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
I don't know.
Have not been sent to anyone other than the defendant, Your Honor.
All right. So there was.
Can I just say this trial is going to take freaking forever because she's going to go on these little tangents and arguments and sidebars and want explanations and pretend or assume that she's the smartest person in the room to her own self. And it's going to be a shit show. Shit show.
Was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state. And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's order denying the motion to dismiss for violation of confidential communication.
So, Lori, this whole thing that you just brought up, it's not going to get your case dismissed. Sorry. Again. Shut down, shut down, shut down, shut down. He's so patient, though.
All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 20.
Okay, now she's doing the prosecutorial. Okay. Now she's doing the prosecutorial misconduct. Because remember, Mark Means did that to Rob Wood. Obviously it didn't fly. But Lori learned all this stuff along the way by all these people she's been working with, but she doesn't quite get it. Let's listen to this one.
21st, let me get that.
This prosecutor's like, how did I get the short straw in this case? Oh my goodness. Ay, ay, ay.
And the state's response. The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response?
Have it.
Hello, Lori. Did you get the response from the prosecutor about your motion to dismiss? Let's see what she says.
Ms. Daybell, did you get that response?
I did, Your Honor.
All right. So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint, that they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that,
I'd like to take each allegation and deal with them one at a time. That's your
I
fir-
understand
that's
that.
your first
My
allegation.
complaint is the interference by the state, Ms. K in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that motion. So I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information. You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We can't get them from them. She's stopping us from getting from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September, the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time. I've
So
been
why
taught-
didn't you why didn't someone file a motion back in after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises to prosecutorial misconduct.
It is.
This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a problem regarding that.
Which is what?
I'm not going to give you legal advice.
Yo, Lori, he's not going to give you legal advice. You are lawyer Lori, attorney at Lori Law. You are supposed to know all of this. You decided to jump in without a concrete knowledge of what it all means, and now you're asking the judge to give you legal advice. Not going to happen, not going to happen, lawyer Lori. Say that 5 times.
All right. Your second allegation, the prosecutorial misconduct, we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only 2 parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it, and you're just taking her word for it, like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom? I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation, is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do
All
we
right.
know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
not a witness anymore because you just precluded him?
All right. You can interview him. You can have your investigator interview him.
So even though he's not a notice witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
Do you hear her whisper? Of course. Of course. He's denying my motion again. It's unfair. Of course he's denying my motion again. You know how she talks like that with her, like, and again. That Lori voice, you know what I mean? Sorry, it's probably really annoying for me to to do that.
All right, 609 motion.
One more motion
The
here.
state's
maybe.
alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609, the court finds that limiting the number of convictions and the nature of the convictions to be appropriate as to not be overly prejudicial. There is an interest in allowing a jury to know that the defendant's been convicted of at least one felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do believe that the court should allow for at least 3. There are multiple dates and multiple victims in those and multiple different
I hate this part. Honestly, I hate that the jury doesn't get to know what they've already been convicted of. She's been convicted of 7 she's been convicted of 7 felonies, and they're not allowed to tell the jury. Hopefully, I just don't like that part. It feels like secret squirrel. Yes, we don't want to prejudice we don't want them to be prejudiced against her based on what she's already been convicted of. But at the same time, doesn't that talk about character and who you are and what you're capable of? I always have had a problem with that one.
distinct incidents. And I believe that it would be appropriate to, when we're talking about the credibility of the defendant, to allowing in 3 of those.
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first degree murder and grand theft by deception. Those are counts 1 and 3 specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's response asking that all of them be precluded. Let me hear from the defendant.
One second, Your Honor. Your Honor, I haven't had a time to, I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can table it till later in the trial because again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now, but depending on tomorrow how far we get in the jury selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made. All right, I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
I think just for the record, Your Honor, in terms of allowing in witnesses the gallery, I think that you had indicated you would reserve one row for the next of kin.
Yeah, let's discuss that. We're going to put up signage after we complete jury selection. So the first row on both sides behind defense counsel and behind the state will be reserved for immediate family members, next of kin, those sorts of people, relatives. The very last row on both sides will be reserved for media. And then the middle rows in between those two will be kind of a first come, first serve general public viewing area. Any questions about that?
I do just want to make sure that, assuming we are leaving on the defendant's mother, father, sister,
Well, if they're potential witnesses, they won't be in here.
the state will be invoking the rule of exclusion.
Do you understand that, Ms. Daybell?
I do.
All right. So as long as people that we haven't already addressed other than Mr. Eaton remain on the witness list, the rule of exclusion would be, in fact, it means that they won't be allowed in the courtroom except for your investigator can be in the courtroom.
So if Lori has her mom on the witness list and they can't be in the courtroom except for the investigator. Interesting. Lori probably doesn't want them in the courtroom.
And they're precluded from talking to anyone about their testimony or other testimony until they're released as witness.
Good luck with that. I'm just saying. I'm sure they're very nice people, but, none of these people have followed the rules.
Mrs. Anything else from the state for today?
I don't believe so, Your Honor.
All right. Anything from the defense for today?
A couple of things, Your Honor.
Of course, she has a couple of things. Of course, she does. She's Lori.
We need to discuss the,
How the division would like the media exhibits.
What?
How the division would like the media exhibits, if we're presenting recordings or audio, individual flash drives for each exhibit. There wasn't,
Depends on how you're going to present them, but I would say, yeah, probably one flash drive per recording or exhibit.
and then I'm guessing 3 copies, one for state, one for,
I don't know that you need copies if you've already disclosed it to them. Just tell them what it is when we're marking it, and tell the clerk what it is with the description so it's clear on the exhibit list which exhibit is what.
one more thing, Your Honor. I wanted a clarification. In your minute entry dated the 25th regarding the defendant's motion to remove restraints. So my understanding when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, 1 or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimal amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering, because the DOs had a question about it with me this morning, so.
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt, because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want additional deputies.
Well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read
Lori doesn't want the belt. She'd rather have the armed guards. Whatever, Lori. She's making everything complicated. Just wear the belt and be quiet. Oh, 5 years later, I am so over Lori Vallow Daybell. I am just so over her. Like, will she ever just go away? I hope after these 2 trials, she just fades into the sunset. There's so many other cases out there that we need to follow. And her case has taken over so much time and such a chunk of people's lives that I can't even believe she's doing this. She's already convicted. She's in prison for the rest of her life. Her appeal is going to go nowhere, in my guess of opinion. And she just wants to make everything more difficult over and over and over again for everybody.
I read their response and their recommendation, and that's my order.
So what is it exactly?
That's my order. So what is it exactly? Tell me again.
That you have to wear the rack belt, but not the leg restraint.
And that they will or will not have armed guard?
It's up to them.
Okay.
All right, so tomorrow we're going to.
Oh, this judge is going to be so over her. He's already over her, I can tell. He's trying to have really, really good patience with her. But, it's like when I have patients, like an actual patient that's super uncooperative, passive aggressive, not willing to listen or do the recommendations or follow the doctor's orders, that make my visits hard. I have the option of sending every other week, of sending a different nurse, like one of our LVNs. And guess what? The patients that work with me, that are kind, that are appreciative, I go to them every week on my once a week visits. The ones that are freaking not, they get the other nurse half the time because we're going to share this, right? So Lori, being Miss High Maintenance, as probably she always has been, is treating the judge as if she is above him. Like, Your Honor, she is saying Your Honor, and she is saying thank you and stuff like that, but she's very disrespectful in her attitude and her questioning. Okay, everyone, I'm going to try to edit this really quick so I can post this tonight. It's a work night, but I'm going to do my best. It's not going to be as fancy schmancy as I like. Not that my videos are fancy, but I'm very anal sometimes about editing, so it may be a little bit more scattered with my commentary, but I do want to get it out there to you guys because you guys, we have been involved in this case from day one, literally before anybody. So we're going to continue. Thank you for all of my diehard people, subscribers, and members. I appreciate you so much. I appreciate you so much. I am looking for some more mods. If anybody is willing, please let me know. And stay safe and stay well. I'm Kathy. I'll see you soon. Bye-bye.